Good evening, ladies and gentlemen. At this time, I would like to ask all council members to please turn off or at least set to vibrate your cell phones and electronic equipment. Today's date is October 10th, 2018, and the public hearing of the Stratford Zoning Board of Appeals will come to order to hear those petitions advertised for this session. For those of you not familiar with our process, each petitioner or their designated representative will present their case to the board. When they have concluded, board members will then have an opportunity to ask any questions they may have. I will then ask if there is anyone who wishes to speak in favor or in opposition to the petition. We ask all petitioners to speak clearly and directly into the mic. After all petitions have been heard, we will then recess to our administrative session. Interested parties are welcome to stay. However, only board members and staff will be allowed to speak at this time. Please be advised that clapping or shouting as a way of expressing opinions on applications is not allowed or tolerated. And I also want to take this time to say that a board member was approached by either an attorney, a contractor, or the applicant themselves. This is inappropriate. Board members already have the burden of making decisions based on the applications that we have. So please take this as a friendly reminder or even as a warning. Any board members that have been approached, you alert the chair will alert the administrator, and if need be, the town attorney. Hopefully I won't have to make that kind of announcement again, but just be forewarned. Before we get started, we are the first application here. The continuance for, thank you, for 350 Whippoorwill Lane, and we asked for a continuance for 700 Margarita Lawn. Will be continued next month. That's November 6th. It's still election day, but we will still have the session. So those that are here listening in or having affected by 350 Whippoorwill Lane and 700 Margarita Lawn, I apologize, but we will not be addressing those petitions tonight. They will be continued until Tuesday, November 6th. Thank you. And with that, petition number 1. Mr. Dempsey, would you please read that into record, please?
Petition number 1, 770 Sussex Avenue. Petition of Beverly and Alfred Roberts seeking a waiver of 14.2 to expand a non-conforming structure to allow the construction of an addition incidental to a cooperative residence. Hardship is family requires more space to live a better quality of life. Okay.
Good evening. Please make sure you speak clearly into the mic, identify yourself, your address, and your affiliation to this application, and we certainly will take the certificate of mailing at this time.
Good night. Am I to speak in?
Into
Can
the
you
mic.
hear me? Yes.
Yes.
Good night. So I'm Sandra Gale. I'm the daughter of Beverly Roberts, who is filing the petition or the request, the application. They're pretty much, it's the basis for this is that they're seniors, and the unit that they have currently is an upstairs unit, and it has become challenging for them to go up. So we, instead of needing to sell the unit and buy a flat unit, we thought that that would just work better for them to be able, because they spend 90% of their time downstairs anyway. So we're requesting the addition of a family room that will facilitate for them to be able to have a better quality of life. That's it.
Is there anyone else speaking on behalf of this petition?
Yeah, I would be, my name is George Brogos. I'm a friend of theirs, and I would be helping them to do this.
See, you're the contractor?
Yeah, I'm in that business, yes.
Your name again?
You repeat your name? And
George
address?
Brockelson,
How do you spell that?
Brokelschen.
And your address?
What's that?
Your address, where you live?
433 Carroll Avenue in Bridgeport.
Does the board have any questions? Mr. Whittick?
Yeah, I have a question more from Jay. Do we know if, 'cause these units have been there for a long time, do they predate any of our zoning regulations going way back? Or did they conform when they were built? Because, I mean, the lot sizes and how much is on there doesn't appear to be with any regulations that I could think of.
I think, I know that some of them do predate portions of the zoning regulations. You know, I'm not sure that they predate any of the residential zone regulations, which I believe came in the 1950s. But the exact date that these units were built, I don't know. But, I'm sorry. Go ahead.
This is Stony Brook, right?
Yeah, 776
They were
says.
built in the 40s,
Okay.
early 40s, and everything in Stony Brook is 90.
Correct.
What I was sitting with Paul is, when Stony Brook came up, it's the same old thing, non-conforming. So, just a little 2 cents in there.
Thank you. Ms. Streets?
Thank you. First of all, do we have the certificates of mailing?
Oh, yes.
And then the other question I have is that as I was looking through, I noticed that you do have an approval letter from your co-op,
We do.
but it states that you have 6 months from the date of approval to complete construction, and so I'm wondering, what is your timeline? Because if that is the case, you have until November 15th to complete. So what is your timeline?
We believe that
That wouldn't be a problem.
that should not be a problem, because once we get the approval, we have everything lined up in place. As a matter of fact, this should have been on the calendar for July, but because of the hiatus in August and we didn't, we were not so clear as to what needed to be in. So we've had things in place for months now, sort of waiting on the process to play out. So it literally will.
So you're ready to go, you'll have it completed, and you won't have to go back to the co-op again?
Yeah,
To get
we had
another
already-
approval.
And if you could see, we already actually had gone back for an
Yes.
extension already because it was expected to be, and we didn't realize the process was so complex.
Okay.
So, yes, and I don't want my parents to be dealing with construction in the midst of winter either.
It's coming, yes,
So,
okay, thank you.
without a shadow of a doubt, it needs to be done, yes.
Okay, thank you.
Are there any other questions from the board? Ms. Young?
Thank you. Good evening. Are you aware of the memorandum prepared by the Planning and Zoning Administrator dated September 13th describing to the board this proposal? May I give you a copy?
Sure.
I have a follow-up question, but I can give them a chance to take a look at it.
Absolutely.
And just for the record, we did send the staff comments to you. They were returned to our office a few days ago. They were returned to us.
To the address? And it was returned to you?
The comments that you're reading right now.
Okay.
We did send them to you.
Okay.
They were returned to us.
I don't know. We don't normally have issues. Would you?
So I'll tell you my question.
Yes, please.
So at the conclusion of the memorandum, Mr. Hibansky is reminding the board members of our edict, which is to have our applicants demonstrate a hardship that would justify or give reason for granting the requested variances. And although he doesn't get a vote, the administrator, he does try to coach us to make informed decisions. And so I believe that memorandum indicates that the stated hardship may not be sufficient to grant you a variance. So I'm wondering if you can expound further as to what is unique about the property that would allow us to vary the zoning regulations to enable the granting of a variance.
Well, as I said before, as seniors, it's become challenging for them. They have the stair version of the co-ops, and it has become, in particular for my mom, challenging to do the stairs up and down, and so on a day-to-day basis. And so, we determined as a family, instead of needing as seniors on fixed income to sell and go back and find something and buy again, that this, and as a matter of fact, I think it was the board that suggested, Brian at the board, who suggested, okay, well, why not do it that way? So, we determined that that would be the better course of action, because I don't believe they would be able to find something in their price range, in their income range, that would, if they were to leave this kind of setup to go into the wider marketplace. So that's really, the gist of it is that my mother has medical issues, and for sure her husband is a lot healthier, but she has a lot of medical issues, and it just is 90% of their time is spent down there anyway, and if she has to go upstairs to the bathroom and come back down and whatnot, it's for a better quality of life for them.
Thank you for that answer. If I can pose a question perhaps to Mr. Hibansky or the town attorney, whose nameplate I now see. It's my understanding, but I'm more interested in your understanding about whether physical disabilities is a rationale to justify the granting of a hardship. I believe this young lady articulated that's the position her mother is in, and I'm wondering if you have an opinion on if that were to be a rationale used, if that would qualify, quote unquote, as a rationale for granting a variance.
Well, I'll weigh in first. I'm not sure that physical illness would necessarily qualify as a legal hardship. I think that you could possibly spin that into maybe public safety, access for emergency services, ability for emergency services to be able to access someone with medical needs, potentially.
Thank you.
Well, I'd like to interject. First of all, Kevin Kelly is our town attorney. Sorry for the lack of a nameplate. One of the members, John Dempsey, was saying that those particular buildings were built before 1940 or around 1940. So would that be considered part of a non-conforming and pre-existing, if you will?
Thank you, Mr. Chairman. Yes, it would be pre-existing non-conforming use.
Thank you. Any other questions?
No,
Ms. Young?
thank you.
Thank you. Thank you, folks. Is there anyone here that would like to speak? You may sit down.
May I ask a question?
Absolutely.
What is the meaning of pre-existing non-conforming? Like, you guys understand that, but
You want to?
It means that the use, the development there, it pre-existed the regulations that say you can't have more than one house on a property. Your co-op is one very large property with lots of little houses on it. It doesn't necessarily meet the rule that says a house has to be set back 20 feet. So it doesn't conform to today's regulations because it was built prior to those regulations being drafted.
understood. Thank you. Do I need to give this back to you? Thank you. Thank you.
You're welcome. Is there anyone here that would like to speak in favor of this application? Seeing none, is there anyone here that would like to speak in opposition of this application? Seeing none, is there a motion to close this petition?
Motion to close?
Motion to close, Ms. Young, second by Mr. Dempsey. Okay. Mr. Hoydick, would you please give us the pleasure of reading item number 2?
Yes, sir, Mr. Chairman. Item number 2, 577 Woodlawn Avenue, petition of Lance Ferrucci, seeking waivers of 4.2 to permit the construction of a front porch and rear deck incidental to a single-family dwelling in an RS4 zone. His stated hardship is no place to sit outside, front porch too small.
Good evening, sir. State your name, your address, your affiliation to this application, and we'll take your certificate of mailing at this time.
Yes, hello, everyone. My name is Lance Ferrucci. I'm a home improvement contractor. I'm representing Jennifer Bernstein, the owner of 577 Woodlawn. I live at 60 Hanford Avenue, Bridgeport, Connecticut, 06605. We'd like to build this.
Just before you get started, the
Oh, sure.
applicant has already submitted their certificates of mailing to our office.
Oh, yeah, I'm sorry about that. I guess I jumped the gun on that. Thank you. They've hired me to, if we could, if you'd allow us, to build a small deck in the backyard. They're a young couple, and I assume perhaps they'll have children in a year or two, and they enjoy the outdoors now, but there's nowhere for them to sit down and have a meal outside. So that's really the catalyst for why they'd like to have a deck. We noticed that the surrounding neighborhood, most of the homes have decks, and they're beautiful homes. It's really a pretty neighborhood. It's a beautiful house, and I guess they rented there for years before they finally bought it. But let's see, is there any questions I can answer about the deck, or what are perhaps your main concerns?
Any questions from the board? Mr. Hoydick?
Porch in the front, is it going to be covered? Will it have a roof?
No, it won't.
Just
So
extend
right
it
now
out and steps?
Right now, it's just a stoop.
Yeah.
There's
I saw
about
that,
3
yeah.
risers or so, and it's so tight to the house that when you open up the storm, it actually hits. It doesn't even, you can't even get the storm to open 90 degrees. So it's really odd.
So you're just coming out about another foot, basically.
Yeah, and in fact, now, I guess they were trying to stay, when they built that front stoop, they were probably trying to stay as close to the house as possible.
Right.
And you actually access the stoop from 2 sets of stairs on the side. And then you try to open the storm and get in, and the storm hits the wrought iron railing.
Yeah.
So perhaps if the steps and risers access the front door from the front, and there was some wrought iron on either side, we'd still be able to get the storm door open and access the front of the house that way.
It probably would be safer, I would think.
I would think so, because right now, right now, for instance, in a fire, I would think it would be tough for the firefighters to get through with their tanks as it is now. So I believe the accessibility would be better if we change that around a bit. But
That's good, thank you.
thank you.
Any other questions? Ms. Young?
Good evening.
Hi.
As I asked the last applicant, have you had a chance to read the memorandum from Jay Hibansky about this proposal?
I did.
I have a copy if you need to see it again.
Oh, would you mind? Thank you very much.
I have a question after you familiarize yourself with it.
Yes, and I remember the question as to why we request to build the deck to 9'4" when the setback is 10 feet for the side setback. And however, and the house though is only 4 feet. So the house way exceeds the setback. But to answer that question as to why we wanted to bring it to 9'4" rather than 8 inches less and stay at the 10-foot setback would be, we wanted to intercept the existing porch up above. They thought perhaps they'd like a second way down to the deck from the screen porch. We would cut in through the screen, we'd install a screen door. So they'd have like 2 accesses to the deck, one over by the kitchen and one down to the deck. So if I leave the setback at 10 feet, I probably won't have room to put a door on. It won't intercept the screen porch enough to get a screen door. So that's why we needed those extra 8 inches.
Thank you for addressing that question. I believe another question raised in that same memorandum had to do with, has the applicant explored any alternatives to reduce the coverage, a trade, if you will? Could we turn the paved driveway into something of a pervious material?
I'd like to answer that and say that they've already, in years gone past, someone had added like a makeshift bump out to the front of the garage, and you could see it on the survey. Jim Dennison included it in the drawing of the survey. It shows a little 2-foot bump out on the garage. I assume in years gone by somebody had a large thin Cadillac perhaps, and they cobbled together in a very poor workmanship like a little lean-to style bump out so that they could move their overhead doors out about 2 feet, and they probably just squeezed their door in. Well, for 2 reasons, we went ahead and changed the dimension of the garage back to the normal. We took the 2 feet bump out off, re-sided it, and put in a single door, and so therefore since the survey has been done, we gained 36 square feet. We eliminated 36 square feet of coverage, hoping that perhaps you would recognize that as a plus on their side. They spent a good amount of money. I think it was the total money they spent on the new door and the work to remove it was about $3,500. I think that answers your question. We have explored ways to eliminate the coverage. One of them was the garage, which we did.
Thank you. Follow-up question to Mr. Urbanski. If I heard our applicant's description, the conditions on site have been modified since the survey was delivered to us to reduce the existing coverage, but it sounds like not so much that they are able to do away with that need for a variance, so there still is a need, if you can confirm that, for a coverage variance. Do you feel comfortable knowing what coverage variance we'd be granting, assuming we granted one?
Let's see. Well, it looks like they're removing 32 square feet. Even if there weren't any other expansions, it still would. If there weren't any other expansions and all they did was remove that section, it would still be 27% coverage. So there may be 1% fluctuation with that. But I think, I'm pretty sure the survey has always accounted for that removal, and it's always been at 32%. Isn't that correct? I don't think anything has changed with the building coverage. If I'm understanding your question correctly, Commissioner Young.
I think you are. I'm just trying to make sure that if the board were to grant this variance, that we have some record left behind as to what did we actually grant, and right. Wanting to make sure that we're not leaving your office devoid of that information.
Correct. I think if anything, it would be a waiver of from 25% to maybe 31.5%. I would just think it's safe. A safe bet would just be to have it be 32.2%.
Thank you. One last question, sir.
Sure.
I'm just going to speak a little louder because the voice is in the hall. I believe the memorandum from Mr. Urbanski concludes by asking the question he asked of all of the applicants, what's your hardship? And if you see, I think on the flip side of that memorandum, Mr. Urbanski apparently was in a generous mood and offered some suggested alternatives to the one that was put forth by the applicant, that one might say are more of the traditional hardship variety. Did you want to expand your position to take advantage of the language in that memorandum?
Would you give me one moment to just quickly look at this? In other words, I have to be honest with you folks. It's tough for me to get my hands around what you consider a hardship and what isn't. For instance, the last folks that were up here said that they're sick and they, if sickness doesn't count as a hardship, I really have to admit I have trouble figuring out what is a hardship. The word hardship is really, it's tough to get my hands around, because
Again,
I'm sorry.
Forgive me for interrupting,
Sure.
but I think Mr. Urbanski is giving you some language that might be useful to you on page 2. My understanding, subject to Mr. Urbanski correcting me, is that hardship is traditionally associated with the land, not the people who own the land. What's unique about the property, not the people who own the property.
I see.
Just
Okay.
in a nutshell.
And so would you consider you don't consider it a hardship that they don't have any way to be outside without being in direct contact with the ground, where they could?
If you're asking my opinion, I don't speak for the board, but my opinion is no, I would not. I consider that an inconvenience. I'm very sympathetic to it. But is it my opinion that's a legal hardship? No. But again, on page 2 of that memorandum, you'll see some language from Mr. Urbanski that speaks to the hardship arguments that are tied to the land.
The COs, however, the unusual conditions present lot area, lot depth, lot width would allow.
Can I borrow yours?
However, the unusual conditions present.
I hate to put words in your mouth.
No, I understand you're trying to
Particularly in
help. I
front of
really know you're trying to help me.
I don't want to do this in front of the town attorney, but here I go. In parentheses on page 2, Mr. Urbanski says lot area, lot depth, lot width.
Right, I see that. In other words, the dimensions of the lot are really is what is causing the dimensions of the lot in relation to the size of the home, these big, beautiful homes they put on these rather small lots, and then including with a 2-car garage, has caused really the hardship of not being able to build anything else, like a porch or like a deck or a porch or a proper stoop for the front.
Thank you very much. My questions have been answered.
Oh, thank you.
Does anyone else have any questions? You may be seated.
Thank you.
You're welcome. Is there anyone here in attendance that would like to speak in favor of this petition? Seeing none, is there anyone here that would like to speak in opposition to this petition? Seeing none, is there a motion to close? Mr. Hoydick?
Second.
Ms. Young? It's closed. Ms. Streets, would you like to read the last petition for tonight, please?
(2381) Barnum Avenue, a petition of Jose Adolfo Carsamo, seeking a waiver of Section 7.3 and Section 12.5.7.1 regarding the required 9 off-street parking spaces for the proposed takeout restaurant in a CA zone, the hardship being building constructed in early 1900s without any off-street parking.
Thank you. Good evening, sir. Please state your name, your address, and your affiliation to this application, please, and we'll take your certificate of mailing if you have it.
Yes. Good evening. My name is Jonathan Klein. I'm an attorney with an office at 1445 Capitol Avenue in Bridgeport. I represent the petitioner tonight, Mr. Carcamo, to To clarify, actually, my client is the seller of this property, JAD Family LLC. Mr. Joseph Pizzone, who's the manager of that LLC, is present with me. I'm handling this for Mr. Carcamo as well because his attorney, John Floric, has a conflict of interest in presenting anything, of course, to this body, so I'm carrying the ball for both. I have the certificates of mailing here, copies of the letters, the green cards. I sent out 11 notices to the surrounding property owners. 4 of them I didn't get green cards yet, but I printed out from the U.S. Postal Service website the information this afternoon. Shall I proceed?
Absolutely.
Yes. This property, 2381 Barnum Avenue, which is at the corner of West, is the proposed use there is for the creation of a deli takeout operation. I know that Mr. Urbanski has one copy. I have additional copies which weren't ready earlier of floor plans that are professionally drawn to scale. If I can hand these to the clerk of the commission here, but yes, I think I'm more than one for everyone. And it shows that the total square footage in there is 836 square feet, which means under section 12.5.7.1, the number of off-street spaces that would be required for that amount of square footage would normally be 9. The problem with the property here and where the hardship comes in is that this property was built back in 1900 and it without any off-street parking. And in fact, I just make a note, I know that this issue came up in one of the other petitions that was presented earlier tonight. My understanding, my reading of the regulations is that since this building was constructed in 1900 and zoning regulations didn't exist in Stratford until, according to a case I read, 1927, the structure obviously predates zoning, and Section 12.4 of the regulations states that structures and land uses in existence or for which building permits have been approved at the time of the adoption of these regulations shall not be subject to the parking or loading space requirement of these regulations. So my reading of that is that the parking regulation doesn't apply because this pre-exists the zoning regulations by quite a bit of time, but Mr. Urbanski didn't see it that way, so we've applied. But that's why we're here tonight. But the peculiar characteristics of this property, you have the size, the nature, and location of the parcel and the building at that corner, which has no off-street parking. The lot area, the lot depth, and the lot width just don't accommodate off-street parking. You just can't have it there. And this especially affects this parcel, but not the district generally. For example, the property next door does have a paved off-street parking area. The hardship originates in the regulation 12.5.7.1, which, as I said, otherwise would require 9 off-street parking spaces. And that hardship arises from the application of that regulation to this unique property. This property has been used for quite a few retail purposes over the years. I researched when this was constructed and the uses. I spent a good bit of time with Ms. Fonda, the assessor, and attached to the application is the field card and some old information at the last 2 pages of the application, which show that over the years this has been used as a poultry shop, a shoe shop, a barber shop, a thrift shop. I understand from Mr. Pizzone, even before he owned it, at one time there may have been a deli or a takeout place there. But it's had a lot of these retail uses, and I think the fact that over a 65-year period that's happened, that's evidence that the proposed use as a takeout restaurant is in harmony with the purpose and intent of the regulations for this zone, with due consideration for the public health, safety, convenience, and welfare. The focus of this body, I'm sure, is, well, is there adequate off-street parking, adequate on-street parking available in the area? I have some, the answer is yes, and I have some photographs that were taken during lunchtime of the area, just maybe 2 weeks ago. Photographs, and I have color copies of these, of West Avenue, which is the corner street. And I have several sets of those, if I may hand those to the Commissioner.
Mr. Chair, question before I take these exhibits. Do the documents identify what you just described, the date these photos were taken and the location?
It doesn't, let's see, there's no date on these printouts, but the person who took the photographs, who is the real estate broker for my client, is here, and she can attest to when she took them and where she took them. If you'd like her to step forward.
I would just suggest it might be useful for the record if that was a supplemental piece of information you added, just to have us know the when and the where.
Sure. Let me ask her to come forward and identify herself, and she can answer that question.
Yes, good evening. State your name,
Hi,
your
Cynthia
address, and
Tokales, T-S-O-K-A-L-A-S. My address as well?
yes.
3 Honeck Street, Milford, Connecticut. The date those pictures were taken, and I really apologize for not having a label on it, was September 20th at 12 noon.
Is that a weekday?
Yes.
Not a holiday?
No.
Thank you.
Okay.
And she took these pictures herself.
Mr. Chairman.
Yes.
Mr. Chairman, before the witness leaves, could we bring her back to find out what her, I heard that she stated her name, but I'd like to know what her professional background is, when those, you got the time and the date, but what the pictures actually show,
Sure.
and to get a better authentication of the documents.
Sure.
One more point of clarification. Were we each supposed to take one? There's enough for each of us, or is this a series of photos, in which case all of them should stay together?
Each bunch that's clipped together, I think, is a
There
set.
are two. One's looking east on West Avenue, and one's looking west on West Avenue, right outside the store.
Thank you. I'll let you address the town attorney's question.
I'm sorry. Could you repeat the question?
Please speak into the mic.
Sure. First, I'd like to know what your professional background is.
I'm a real estate broker, and I represent the owner.
Okay, and are you familiar with commercial properties in Connecticut?
Yes.
Okay, and could you identify which photograph is, I'm going to say, a western look, and which photograph is the eastern look?
I can. The housing on the left-hand side of the street is looking west on West Avenue. And that's adjacent to the building. And then the sidewalk with the building on the right-hand side is McDonald's. It's across the street. And the purpose of these pictures were to show that at noontime during a work day, there was plenty of on-street parking. You can see there are no cars parked there. And this is right outside the building.
And as a normal course of your professional activity, is this something you do on a regular basis?
Yes.
Okay, thank you.
I drove by the property myself this afternoon at about 3:15. to, again, just refamiliarize myself with the property and look at the parking situation. And I saw there on both West Avenue and Barnum Avenue, there were at least 25 available parking spaces at that time. On Barnum Avenue, there's 30-minute parking allowed on the street there, and there was a lot of space there. And West was just wide open on that one side of the street where there is parking. I did note, I did receive, and I appreciate receiving from Mr. Habansky his memo with his notes, and I say appreciate that because I know that in some other towns where I've done this kind of work, I don't see it until I get to the meeting and I don't get a chance to respond to them. But I believe we've covered the comments, so I'd like to just take a moment to go through that. First, there was he was telling us that the floor plans that had originally been submitted had not been professionally drawn to scale, and although we remedied that with the plans that you now have. And it shows that the seating area, shows that the floor area is, as I said, 836 square feet, which is where we got the what would otherwise be 9 off-street spaces, which would be required under the regulation. You'll see in the drawing that I've presented you tonight, there is no seating depicted in there because there is no seating planned for this. It's strictly a takeout place. You come in, you order your food, you take it, you go. There's no seating. And that goes for both indoors and outdoors. There's no seating. Mr. Bansky said the board should inquire with the applicant as to what alternatives were sought during the development of this application regarding parking alternatives. For example, he says, has the applicant considered a parking agreement with neighboring uses? The answer is that there weren't any alternatives that Mr. Carcamo pursued. He didn't see that there were any. There's no neighbors that could accommodate additional parking that we're aware of. And I also note my experience has been for various land use boards in different municipalities is that if we ever present a parking agreement, a lease or a license to park at neighboring properties, invariably the board says, well, that can be revoked, so that really doesn't get you anywhere. So I don't think even if we had it, it would be particularly helpful. I appreciate the suggestion, but I don't think that would have been helpful, but it's not available to us here anyway. With respect to, see further down his memo, he said the subject property does not conform with the following zoning development standards: lot area, lot width, and lot depth, making it exceptionally difficult to develop the property in compliance with the zoning regulations, which is one of the things that I mentioned a little earlier. And for the other reasons that I stated in the petition and in my opening remarks, so we believe that there is a legal hardship here. If you have any questions, I'd be happy to answer them.
Well, thank you. I have a question here. You're in possession of the staff review report.
Yes.
Where it says that statute 1.13 says a takeout restaurant shall have 9 seats or less. And, you said that this floor plan was revised?
Well,
because it doesn't show the 9 seats. It doesn't show any seating.
It doesn't. I don't know if revised is the right word. The plans that had been provided earlier when the application was originally provided were not professionally drawn or not drawn to scale. When the need for that was brought to our attention by Mr. Urbanski, we obtained professionally drawn plans to scale. And in the course of having those plans drawn, we inquired of Mr. Carcamo whether, how many seats did he plan to have, and the answer is 0.
Well, for the board to make a decision, this is what the statute states, so.
Right, it says 9 seats or less, it's less.
And I just want to ask, when you want to designate these parking spaces, how would they be designated? Are they going to be painted, or are there going to be signs which probably go through zoning? I mean, how would you reserve 9 spaces in a very, very tight
We can't reserve spaces on the street. It's a public thoroughfare. Individual property owner doesn't have the right to reserve parking spaces on the street. But the point is that there are more than enough spaces available different times of day for people to park for the brief period of time it takes to come in and either order their food and pick it up, or pick up food that they've ordered over the phone in advance. I think the parking regulations on Barnum Avenue that with the signs posted there say 30-minute parking certainly are adequate to deal with that sort of thing. I mean, the average person ordering takeout, whether they've ordered it in advance or order it when they get there, are only going to be there for a few minutes. I don't think so. I mean, I suppose that kind of thing could happen on any street for any use. But, I mean, I have, for example, I have my office in my home. People park in front of there all the time who are not coming to me, and if I have a client coming, they can't park in front of us, but I don't like it. But, again, it's a public thoroughfare. And there's other places to park. It's just not right in front. But people coming here will have adequate place to park. This business is not going to be open at night when the people who live on West Avenue are going to be there. My understanding is that it'll be open from early in the morning till maybe 3:30 in the afternoon, something like that. So it doesn't present a problem for the residents in the area. And from the photos that we've presented, and from what I've told you about what I've seen, there's the availability of on-street parking areas, particularly for people who are going to be there for only a few minutes at a time. For a small business like this, I just can't foresee that there's a problem.
Does anybody else on the board have any questions? Mr. Hoydick?
Yeah, I just have a couple. Jay first, if I could. After seeing the more detailed plan of the interior, do you believe that 9 spaces are still adequate?
Yes, after taking the scale to the plan that's appropriately scaled, the total square footage was 800 square feet and change, round up, so that's nine parking spaces. So the variance as sought and requested and advertised is correct.
It's adequate.
Correct.
Also, did the police department review this?
They did. The comments from the police department.
I didn't notice.
Yes,
that.
I
They could be in our
received,
packet.
Mr. Bansky provided me with a copy of an email dated September 14th.
Oh, there they are. I didn't see that.
From David Gugliotti at the, Lieutenant David Gugliotti from the Stratford Police Department. And he said, Jay, in regards to this takeout new business, I have no problem with the business coming in.
I didn't see mine.
It may not.
Yeah.
It may not have made its way into your packets.
No, I didn't see it, but
apologize.
Ms. Streets had it, so it probably was in there. I just couldn't find it.
Apologies.
Yeah, and he, just for completeness, his comments, and I'm quoting, he says, in regards to this takeout, in parentheses, he puts new business, I have no problem with the business coming in, but want to make sure that they understand parking spaces on the roadway are not reserved for them or anyone. They're first come, first served. They must park legally, and they cannot store their business trucks, vehicles on the street. And as I've said, we fully realize, they can't reserve spaces on the street.
That's fine.
Yeah.
Ms. Young?
Question for Mr. Hibansky. The zoning location survey has a parking chart on it, and it identifies for a takeout establishment, 9 spaces would be required. If I understood the history previously retail establishments have occupied this space. Does the zoning regulations put this proposed establishment in a different use category so it's not enjoying the same use group that the prior tenant enjoyed? If that makes...
There was a takeout restaurant there at one time when we did our history of it, but as the applicant states, there was a litany of uses, and the parking regulation for takeout, that is a relatively new regulation that was somewhat, we relaxed in order for us to be able to, the town to be able to allow for smaller startup businesses to open up without the burden of having to provide too much parking.
So I'm trying to understand if your office was presented with a traditional, quote-unquote, retail tenant who wanted to occupy this space, would they be allowed as a right without having to seek a variance to parking requirements? It's because this tenant is not of the traditional retail variety, but is in the takeout use group?
If it was the same exact use as prior, then no, we would not have required parking. But because the use had changed, it went from a bakery or I can't remember. I don't know offhand remember offhand what the last use was. But the last use was not a takeout. That's what triggered the new parking calculation.
And if I may ask a follow-up question of you, sir, I heard you describe that your prediction is the customers will quickly come in and come out. My question is about the employees who I assume will stay longer. What is the estimate for how many employees, and could you, again, for the record, identify what will the duration of their stay on a daily basis be, from what hour to what hour?
Let me find out. Mr. Carcamo tells me he anticipates 4 or 5 employees. The hours from 6 in the morning till as long as 7 in the evening. My understanding before what I said till like 3:30 was I misunderstood, but it's still, he said 6 to 7.
Thank you. That raises some concerns for me.
Can I address those concerns?
I'll just try to articulate them, and then yes, I appreciate your offer. Mr. Herbansky in his memorandum talked about some mitigation is for applicants when they don't have adequate parking is to seek a private agreement with a landowner in the vicinity. I think he said 200 feet. Have you made any attempts to secure enough parking, at least for those employees within the vicinity?
Mr. Carcamo is not, and it's his understanding that doesn't believe that it's that he could have. But the answer is no, he did not. The only area I think that would qualify for what you're describing would be the property next door, but I don't believe they would have space available. But again, also, as I said before, even if we were to have an agreement, as I run into other municipalities, those agreements can be defaulted on, they can be revoked, and they're of limited use. So I don't think it helps either Mr. Carcamo or the town, quite frankly.
Last question. Did I hear you describe whether or not there would be any delivery vehicle associated with this establishment?
That didn't come up. I believe any delivery of supplies typically happen first thing in the morning, early in the morning.
I guess what I meant was if I want to be a patron of this establishment, can I have it delivered?
Oh, I mean, do they make deliveries? Let me find out. Mr. Carcamo advises me, yes, they will do deliveries.
So I wasn't trying to set you up, but that begs yet another question. Now we have the 5 employees plus the delivery vehicle.
Well, it's not plus the delivery vehicle.
One of those
One of the
5.
employees would deliver, right.
Is that employee arriving in the delivery vehicle, or is he arriving in his own car and then getting into the delivery vehicle, in which case there's a total of 6 vehicles?
Just to make sure I don't misspeak, let me check with Mr. Carcan. He tells me the employee making the delivery would use his own car, his or her own car. So it's not an extra vehicle.
Thank you.
Attorney Klein?
Yes.
Oh, thank you. I didn't want to mispronounce your name. Was there any contact with some of the other, what are the other businesses that are either shared in that building or directly around it?
All I know about the neighboring properties are the names of the people I sent the notices to. There are different kinds of other retail businesses I know from across the street. There's across Barnum Avenue, that is. Commercial establishments on West Avenues. Obviously, on Barnum Avenue there are. I've not heard from any of them.
Have there been any attempts to reach out to them?
Maybe Ms. Tokalis can answer that.
Yes, ma'am.
In regards to the question about some of the other retail establishments that are on Barnum Avenue or adjacent to the building, there is a takeout Chinese restaurant. There's a hair salon. Across the street is a laundromat. There is a variety store, all of which do not have off-street parking. And these are all on Barnum Avenue, and one Chinese restaurant, hair salon are adjacent to this building, and there's still plenty of parking on the street.
Thank you. Does the board have any more questions? Thank you, folks. Thank you, sir. Is there anyone here that would like to speak in favor of this application? Hearing none, is there anyone here that would like to speak in opposition to this application? Hearing none, do we have a motion to close the public hearing? Ms. Young, second? Mr. Dempsey, all in favor? Any opposed? The public session is now closed. You may stay for the administrative session, but as was stated, there will be no comments or questions from the audience. Thank you. You want a quick break? 5 minutes, or do you want to just go right into take a minute? Oh, break for 5 minutes.